Okay, thanks. Well, it's good to be here. I've enjoyed coming at least once or twice. I should probably check with shares. So what I'm going to do is set the stage, give a little context, and then Honor's going to take it over. As Betty said, I teach at the law school, and as part of that, I run our experiential programs. One of which is the clinic, the Conservation Clinic. Clinical education law school context means that student lawyers basically work for an attorney on projects across a wide range of different issue areas, environmental and land use law being just one. We have quite a number of legal aid, law, those sorts of things. I direct our conservation clinic. I also direct our program in Costa Rica, which we've sort of developed into an applied program in a very short period of time, working on a variety of projects, both in Costa Rica and elsewhere in Latin America and internationally as well. And so I'm going to talk a little bit about this last year because it was a particularly productive year in Costa Rica. We spent the summer there 1 month. Law students, graduate students, but I'll call non-traditional students because they come and aren't necessarily receiving credit, but are getting the experience and participating fully in the class. We had at least 2 last year and a cohort of about 13 students. So we took on 5 projects last year. We put students into small groups. I worked with a colleague there, Frank Nicaragua, who's a graduate of this program, and a perpetual PhD student of Marianne Schmates. He does fabulous work, if only it would be on his PhD, but I'm responsible for some of it. We've been working together for a period of time. We're deeply embedded in both the culture as well as the policy environment of Costa Rica after 20-some years of doing this, and that's very helpful for our ability to reach out to people that would be important on these various projects. So we took on 5 projects last year, and I'll talk about the first one last. One of these, creating an Amazonian Indigenous Rights Digital Network, Rica, and Neiva, the last name already. That. Brazilian students, they were quasi-traditional, I'd say. They were here at Neiva on a bridge program, program that you all have here, Maida in the geography program, PhD. They worked and wrote an incredible proposal, an elaborate proposal to basically provide different ways to identify different ways of providing legal assistance to indigenous communities in the Brazilian Amazon, particularly those affected by dams, which is our initiative here. One piece of that proposal was to look at the idea of creating a cohort, a group, a program of community-based or indigenous paralegals. So these would be representatives within an indigenous community that had the leadership ability, the literacy skills to provide services to their community above and beyond what an ordinary individual might be able to, but certainly not to the point of rising to being an attorney legal culture there. The idea is that to increase their community's ability to participate in the processes, procedural participation is key in many of these programs, processes of creation of large dams and other infrastructure projects. And that was, again, we only have a month when we're in Costa Rica, so we just can get things started. With that in mind, picked it up when we got back with Simone's help and crafted that piece of that into a proposal, an interdisciplinary proposal that has just been notified, funded by the Superbiological University here. And so we're going to be able to advance that initiative. Hunter and her colleague, Pilar, is Pilar here? Yeah, Pilar Morales, who's in the MVP program, have been looking at the landscape around the world of programs where community-based legal services are provided by non-lawyers, doing an excellent job of finding them on every some way, shape, or form, from the Philippines to Canada, elsewhere.
Betty, yeah, I know.
Oh yes, and Betty is, of course. But in any case, with that project, a couple things will happen as a result of that. They're doing this basic literature review and search for other programs in the Philippines, Ecuador, Canada, interestingly, and in Mozambique, country. And the other piece of that, which is interesting, is they're looking for instances where a legal framework actually incorporates or requires the incorporation of traditional ecological knowledge, the knowledge that indigenous people have, the traditional peoples have about their environment that isn't necessarily captured by Western science, that incorporates that into these participatory processes. The one place we found that we're certain of is in Canada, where those that are writing environmental impact statements, those that are participating in the licensing of large projects like mines and so forth, have to reach out to the indigenous communities for their particular knowledge base and incorporate that into the decision-making process. Necessarily mean the decisions go the right way, but that's the process-based side of it. A second one, this consultancy on the governance of protected areas in Ecuador, Guinea, Hazmi, is here, and she worked on that. This was done through a grant from the wildlife contract, I suppose, better put, to the Wildlife Conservation Society, which is based in New York. They have a field office in Equatorial Guinea, and a former PhD of the University of Florida who runs their field office in Equatorial Guinea, and he reached out to us to assist with some drafting of a new protected areas law for that country. With Hazmin's assistance and Franklin's assistance, we set out to begin that process in Costa Rica. Again, what happens in Costa Rica can't stay in Costa Rica for a too short a period of time. So Hazmin, myself, Betty, and Franklin worked together on this, wrote a draft law using the laws from surrounding countries, the prior law, and a law before their prior law, because of some changes that had happened, and presented that in Equatorial Guinea. Hazmin and Franklin did to a variety of stakeholders, looking at the larger governance picture there. That is in their council of ministers. So that law is actually moving its way forward. Cristian Barrientos, who was the WCS program manager there, he says that a year or two legislative process, but nonetheless, it feels good to see him enter into that process. I'll leave the rest alone so we have time for the more substantive discussion. So the third project we took on down there actually is in Costa Rica, in as much as the Inter-American Human Rights is in Costa Rica, but it didn't involve Costa Rican law. In fact, it's all international law. And at some point in the late spring, I received a message from the court, as did many other people who the court had knowledge of the area. And we were invited to draft comments, a brief for the court to inform it as it decides whether or not to expand, that's the right argument, its jurisdiction in a somewhat novel way, as requested by the government of Colombia. There's quite a bit of context to that. So we'll move on here to the next slide, and I'll let Honor take it.
So
I'll jump in.
Yeah, the best way to try to tackle this and explain it so everyone understands is I'm kind of going for like a funnel analogy here. So our agenda is going to slowly narrow as we go on. So starting more broadly, what was our project? A little bit more broad still. What was the court? Then kind of narrowing a little bit, what are some preliminary questions and definitions if you're not familiar with the legal concepts? Then getting down into the kind of the meat of the law, and then most narrow, it's going to end with applying kind of everything you've learned throughout the presentation to a case study that we use throughout our brief. So, as Professor Ankersen said, we got the request to file an amicus brief in regards to Colombia's request for an advisory opinion. So, just to clarify, this wasn't a case between two parties that was going before the court. Colombia was asking for an advisory opinion. So an amicus brief, we're filing it, would be, they wanted to their opinion went on 3 questions. So whether extraterritorial jurisdiction would apply, whether environmental damage violated the Pact of San Jose, and whether states have an obligation to prevent environmental damage. So because this is so broad, to focus our brief, we primarily focused on the first issue, which was the application of extraterritorial jurisdiction in an environmental context. So the project as a whole, I worked all last semester on writing the brief, doing all the research. We filed the brief in January. It was accepted by the court, which was great to hear. It's been published on the Inter-American Court of Human Rights website. Other notable people who submitted briefs include the International Maritime Organization, European Center for Constitutional and Human Rights, and Georgetown Law Human Rights Institute. And we were also invited to provide oral arguments in defense of our brief in the next month in Guatemala City. Don't know if we're going to that, but here's a zoomed in of the website. So here we are, number 18 on the list of all the different briefs. And so then an overview just of what the court system is and how it's broken up. So the Inter-American system has 2 main branches, which is the Inter-American Commission on Human Rights and then the Inter-American Court of Human Rights. And so then within this big encompassing system, there's the 2 main governing documents, which is the American Declaration of the Rights and Duties of Man and the American Convention on Human Rights, which is also known as the Pact of San Jose. And the U.S. has signed the Pact of San Jose, but we've never ratified it, and we haven't signed or ratified the Declaration of Rights and Duties of Man. And then it's irrelevant to the research we did, and it's just interesting to note that a right to a healthy environment is not in either the Declaration or the Convention. The only way that these rights have been established for indigenous communities, or when it's arisen, has been through property and cultural rights. So we dealt specifically with the Inter-American Court of Human Rights. That's where we filed the brief. That's who's hearing the request for the opinion from Colombia. So it's established in 1979. It's autonomous, based in San Jose, Costa Rica, designed to enforce and interpret the provisions of the Pact of San Jose, which is what Colombia's request revolves around. And if you are a party to the Pact of San Jose, you've already accepted the court's jurisdiction over any issues that may arise in that dispute. So here's a picture from the summer Costa Rica program of 2 UF students in front of the court. So now moving more on to the preliminary questions and definitions if you're not familiar with it. So what is an amicus brief? That's what I did. What is it? So it is a brief submitted by, it's amicus curiae is Latin for friend of the court. So we're not a party to the case. We are not in the dispute at all, but it's usually submitted by academics and scholars to provide the court with information they may have not been introduced to otherwise, and providing novel takes on how the law could be interpreted, or just helping out the court if there's a particular issue that you think would be beneficial for them to know about. And then another definition to clarify would be what is a mega project, because that's also used a lot throughout my brief and through the project. So the generally accepted definition, there isn't one specific way to define it, but most commonly it's any large-scale development project that exceeds $1 billion US dollars. So good examples, dams, canals, bridges, these would all be considered mega projects. So the next big question to tackle, and it is a big one to tackle, would be what is extraterritorial jurisdiction, and how can you explain that easily? So it means the scope of a state's jurisdiction over individuals that are outside of the state's traditional boundaries. So the easiest way to think of it, and most typically it's applied during a war or an armed conflict. So when a country invades another country and they're putting their laws and controlling the people of another state outside of their own traditional boundaries, that's when it's typically applied. So it's not an environmental legal avenue at all. It's typically a war issue. And so what it does is, when it's applied, is it holds a state to its own legal standards when it's exerting the power over people outside of its boundaries. So it keeps you responsible to your own standards no matter where you are. And so how can you twist this and put it into an environmental context, which was one of the big threshold issues to get out of the way in the brief. So when a state's action causes adverse environmental issues that negatively impact the citizens of another state, you can think of that as a means of exerting the control in creating the extraterritorial jurisdiction. So when a state has a project wholly within its own boundaries, but the pollution and damage to ecosystems, animals is felt outside of those boundaries in another country, that in its own way is extraterritorial jurisdiction. And so then getting kind of those three issues out of the way, so what is extraterritorial jurisdiction, how is it environmental, then you kind of have to answer the bigger question combining the two, which is why is any of this a human rights issue? Why is this in front of the Court of Human Rights? So when it comes to the extraterritorial jurisdiction and the negative effects of mega projects, indigenous and traditional communities are more likely to suffer than others because they have inadequate means to address the problem when the pollution does arise or when the animals are killed. And beyond that, their regions of where they live is also most usually affected by the kind of construction of the project, clearing the lands, getting them out of there to build a dam, a bridge, or something. So the other issue that it makes it human rights is that they don't just rely on the environment for a clean environment. It's kind of dependent on cultural traditions and subsistence. So when the fish are gone, they can't kind of fish for cultural reasons or to actually eat. So it's something that doesn't, it's more affecting of the indigenous communities. When it affects the cultural aspects and the subsistence aspects, under these conditions, you can kind of see that it would be a violation of human rights. So this is where it gets in a little deeper. This was like the meat of our amicus brief. So understanding the law. So in order to make our brief meaningful for the court, I had to go through previous Inter-American Court of Human Rights law, find what we could pull out and say, this would work, and here's how you would apply it. So the first case that kind of gave the big threshold, there's two takeaways from each case that I provided analysis for in the brief. So in Cord v. United States, what the issue arose was when the U.S. invaded Grenada, Grenadian citizens who were imprisoned then filed a lawsuit against the U.S. claiming that they were exerting extraterritorial jurisdiction and their rights had been violated because in Grenada they were not holding, they were violating international norms and there was no due process for people who were in prison. So this is again that key example of extraterritorial jurisdiction, usually in a wartime conflict. So the two main takeaways that I was able to use and kind of promote for our brief is first, the court provided the precedent of what it defined as extraterritorial jurisdiction. So conduct with an extraterritorial locus where the person concerned is present in the territory of one state, so in this case Grenada, but subject to the control of another state, which would be the U.S. forces, usually through the acts of the latter's agents abroad. The second main issue to take away from that case, and is relevant to the case study I'll analyze later, is that the court presented the idea that this action and the agents abroad could be either military or civilian, and that's a big issue because if it's only if they narrowly defined it as only the military, that would be harder to apply in environmental context. But because they said military or civilian, that kind of opens the door to broadening this original definition of extraterritorial jurisdiction. The next case that provided a lot of valuable law for our analysis was Alejandro v. Cuba. So in that case, two American pilots with the Brothers to the Rescue organization were flying over international waters. So it was neither in Cuba's airspace or the U.S. They were shot down by the Cuban Air Force. And so the key takeaways from this case is it provided two things. First, it allowed the court to find extraterritorial jurisdiction applying where there was no geographical connection. So they weren't in Cuba when they were shot down and they weren't in the U.S. They were kind of in no man's land. But that still meant that Cuba was applying their extraterritorial jurisdiction when they shot down the planes. So that was a big issue for being able to apply it to environmental, because you won't always be able to find the direct route to the environmental harm and where does it lie in the ocean. The second big issue that I further provided analysis on, and I'll explain, is the concept of authority and control when it comes to applying the extraterritorial jurisdiction. So in the court's opinion, authority and control was used as a two-word concept, so authority and control, as like almost one phrase. But when the the paragraph where it delivered its actual, like the key of the case, it only used the phrase under the state's authority. It took off the and control. So when I'm reading this and I'm going through, I see this as a way to say, if we're no longer holding to a stricter standard of authority and control, is it easier to just apply and their authority? And so from this, I kind of went off and I did a bigger analysis in the paper of, is there a difference between authority and control, and does it help us environmentally to just have authority? So authority has a more broad definition. So authority is power or right to give orders, make decisions, and enforce obedience. It's not like task specific. Whereas control is a more narrow definition, where it's power to influence or direct people's behavior over the course of events. So it's much more narrow. So if you have this phrase of authority and control, it's going to be harder to find situations where it applies than if you're able to just say the state's authority. And so this is going to be especially relevant when I get to the case study in a moment, because it'll allow states to apply the extraterritorial jurisdiction when there's agents that aren't even associated with the government itself, but are under the authority of the government. So just kind of summarize everything from the law in the most simple form. If the court followed our interpretation that we presented to them of extraterritorial jurisdiction in an environmental dispute, a state could be held responsible for the negative impacts of pollution felt by the citizens in another state. So this is key, because you can say that any action that's done by an agent, whether they're under the authority or control, as long as their actions are producing effects outside of the territory, you can find extraterritorial jurisdiction. So again, that key phrasing of producing effects is critical, because if a project is built completely within the borders of a state, that's not extraterritorial jurisdiction. But if their effects are felt by people in other states surrounding, that's critical to kind of establishing this circle of mega project harm back to holding them responsible. So before I launch into the case study, I'm going to have Professor Ankersen kind of explain the political background. It's something he's interested in, to kind of give a better setting the stage for case study that I'll address in a moment.
Yeah, so the question is, why is Colombia doing it? Why are they asking this advisory opinion on this question, which they've centered around the Greater Caribbean and the impacts of mega projects, which they're describing them large infrastructure projects on resources that would be affect Colombian national, but outside of the jurisdiction of Colombian national? Well, the answer may lie as a way of getting back in Nicaragua, or have a political inclination, because just a few years ago, Nicaragua, actually 2 years ago, Nicaragua had brought a case in International Court of Justice, The Hague, big daddy court of international law. And in that case, Nicaragua was asking the court to limit Colombia's maritime jurisdiction over two small islands, Providencia and Andres, thank you. Providencia and Andres, and the little islands around those islands that are way out from the boundaries, geographical boundaries of mainland Colombia, but are close enough to take Colombia's exclusive economic zone and hopscotch it or leapfrog it into within 200 miles of the Nicaraguan border. So effectively, Colombia, because of those small islands, there's some jurisdictional context, but not important to find that to be the case. Effectively, Colombia has circumscribed the ability of Nicaragua to exploit resources 200 miles offshore, which it otherwise would be able to do but for those islands. So Nicaragua prevailed in that case. The court basically drew little circles around these islands and said, that's yours, Colombia, but you don't get everything. And so Colombia feels like it won. Nicaragua feels like it won. It was a big deal. Colombia was extremely upset and was protesting, saying it was going to drop out of the out of the court's jurisdiction, the international court's jurisdiction, et cetera. A year later, Colombia is filing this action for this advisory opinion, which looks very suspiciously like retribution for the prior case in the international court. Nowhere is Nicaragua mentioned in the briefing on the advisory opinion by Colombia. This is just surmised by all of us who think that's probably what happened. And so we sort of assumed that being amicus, being friends of the court, we can sort of play with that a little bit and we can use that as a case study, and that's what we'll pursue.
So the case study provided kind of two avenues for us. One, it helps to tie everything I've just explained together and see, okay, how would all of these extraterritorial jurisdiction mega projects, how do you put that all together and have it work in the real world? So what it is that we're kind of focusing on, and again, as Professor Ankersen mentioned, this project itself was never mentioned in Colombia's request for the opinion. So it's just something that we kind of took and applied to a situation. So the mega project is the Nicaragua Grand Canal. The proposed project is to build a canal through this kind of blue route here through Lake Nicaragua and create a new Panama Canal, basically connecting the Atlantic Ocean and the Pacific Ocean. So the issues with that are, I mean, just numerous in itself. But the construction isn't going to be just the canal itself. It's going to be, there's going to be a creation of a free trade zone if it goes through, construction of roads. The construction itself of the canal will have a lot of environmental impact. Ecologically, it's going to be disastrous because you'll be mixing the salinity from the ocean and Lake Nicaragua. So those are kind of all the environmental issues. And what makes this case study unique and provided an opportunity for us to address an issue completely outside of the scope of those original three questions that I mentioned that Colombia wanted the court to address is this case, the proposed Grand Canal is going to be privately funded by a Chinese billionaire, so Wang Jing. So he amassed his fortune from having a Chinese telecom company, Zhenhui. From that, he had this idea to build the canal. And so after having all of his fortune, and then he's also going to be partially invested by the Chinese Development Bank, he created the HKND Group, and that is a subsidiary of Zhenhui, and it's the Hong Kong-Nicaragua Canal Development. That company, in its proposal, has gotten a lot of green lights from the Nicaraguan government that kind of shows that it's really his pet project and it's going to be going through. So Nicaragua has passed specific laws that said if the construction isn't finished at a certain time, there's no penalties, there's no penalties for moving the indigenous communities or where the path of the canal is going to go through. So he definitely has an easier route to build a canal if it goes through. One problem that's recently come up is that construction hasn't started yet on the canal, and as of right now, it's paused. Last year, Wang Jing lost half of his fortune on the Chinese stock market. So as of right now, he doesn't have the means to fully fund the canal. But according to HKND, if you go to their website, read any of their press releases, they're still completely on to do it. They already have the governmental green light. So as soon as he gets his funds back, he plans on building it. They're projecting that from start date, they can have the entire canal, free trade zone, and hotels and roads open in 5 years. It seems very ambitious. I don't know if that will actually come true, but that is their plan. And as of today, if you go to their website, that's what it says. So the unique issue that we addressed in the brief that, again, wasn't necessarily asked of, but it kind of is a bigger problem for all mega projects moving forward, is this issue of the private funding. So traditionally for mega projects, the scale is so big, you have to have multilateral funding. So World Bank, there's going to be more institutions involved, more countries involved, and therefore more kind of people checking on things, making sure you're doing things right. The problem with this case is that since most of the fortune was coming independently and anything supplemented was through the China National Bank, so China Development Bank, there weren't as many conditions placed on the planning and execution for the canal. So typically you would have to do the environmental impact statements, environmental assessments, and even if they go through anyway because the money's there, at least there was the effort put in to try to make sure that you're doing things right. There aren't the same limits on privately funded mega projects. So while the China Development Bank does on paper have some standards to follow, to comply to with the money, they aren't always executed to the same level if you're as held accountable with like the World Bank, for example. So the issue that we brought up, just a small part at the end of the brief, is just to say, this is something you really should be looking to for the kind of human rights issue moving forward is there a need for specific requirements to be met for any project that is privately funded, and as the rate of individual billionaires continues to grow and they have these projects, they have these ideas, are they going to be held to the same standard as anyone else? And so, as Professor Ankersen explained a little bit, why is this case study even relevant? If it's just a canal through Nicaragua, who cares? It's only going to affect them. Not quite. So, especially for Colombia, again, taking our liberty as the amicus parties here to kind of make it applicable to the brief, is that the archipelago up here of San Andreas, Providencia, and Santa Catalina are right through kind of the breaks to get into Nicaragua. So concerns that have been voiced about the environmental damage that would result from the building of a canal would be the increased maritime traffic would definitely harm the fragile ecosystems of these islands. And pollution from the construction itself would also cause harm, killing off the fish, as I said in that earlier slide. For the indigenous communities on these islands, they rely on the clean environment for tourism, but they also rely on the clean environment for their subsistence, for their cultural traditions. So if you have increased maritime traffic, you have the salinization of the water different, you have all this pollution. What can Colombia or any of the surrounding states kind of do to hold Nicaragua responsible or make sure that they're not doing it? So that's where the application of extraterritorial jurisdiction would apply. It would, in a situation, if this went through and the court's opinion kind of went in favor of what we said, Colombia would be able to say, Nicaragua, you cannot act so recklessly and endanger our citizens on these islands because you are subjecting them to your jurisdiction. You have to hold them to the same standard. So that's kind of how it all ties in all together and kind of puts the law and the human rights and the environmental. That's why the case study, we like to use it for the amicus, because it made kind of these big picture issues and you could apply it and say, okay, that is something that would be practical if the court adopted this. So, as I said, would extraterritorial jurisdiction apply in this situation if you applied it to the canal? Yes, it would. So, all the issues I addressed, it would be clear that any pollution caused by the construction of the canal would travel, it would cause an effect outside of the territorial boundary of Nicaragua and would go and affect other countries. Ergo, it would be extraterritorial jurisdiction. So that was kind of how we summarized at the end of the brief, saying, if you did it, this is how it would work. And then another interesting thing to note, specifically in this issue, and again, Colombia never mentioned Nicaragua by name, but in their brief, in their request for an advisory opinion, they kept saying, well, would it matter if the states were both members of a treaty? Would it matter if both states were members of Pact of San Jose? If there's this obligation in the treaties to not pollute, does that help create extraterritorial jurisdiction? And from the case law that I analyzed and the argument I presented is that that's an unnecessary step. You don't even have to cross that, oh, are we members of the same treaty? The extraterritorial jurisdiction would apply whether both countries, for example, Nicaragua and Colombia, they are both parties to Pact of San Jose. But they don't need to be in order to find the extraterritorial jurisdiction to hold states responsible when there's pollution. So that was kind of a thing that, in all of their questions, Colombia prefaced, but I went on to say in the brief, it's an unnecessary hurdle you're providing. You really don't need to even say that you're a shared treaty, you have anything of responsibility in that way. So tying everything together and kind of closing something that really can't be tied up in a neat bow would be, moving forward, what would be the role of human rights law in environmental issues? So the issue that the court is going to have to face is if they release this opinion regarding Colombia's request and they make all of the arguments that we've made, or they say that extraterritorial jurisdiction would apply, it would be creating precedent because it's never been applied in this way by this court. So that's something that is likely that they might not make the step to make the formal declaration, yes, it would apply in this way, because it's creating precedent and it would kind of get messy and they don't want to go and make these grand statements if they don't have to. And even in Colombia's request for the advisory opinion itself, it went out of its way to say, you know, environmental law and human rights law, they are connected, we all kind of know that, but you don't have to like make a grand statement to say that they are. We just kind of accept it. So it's something legally that a lot of courts just acknowledge in the moment for the case, but they don't want to make this big proclamation on. And so I mean, from the law that I analyzed, from its own case law, it seems clear that if they wanted to, you absolutely could apply it. But again, do you want to in order to kind of create this issue, and then every time there's an environmental complication with extraterritorial jurisdiction, do you want your court flooded? So the question that you have to kind of grapple with is, you want it broad enough to the definition to be able to have cases apply to it and give people the rights and the human rights and have this apply to environmental. But you also need it narrow enough where the court's not going to have every issue addressed. So does it really want to address itself? And then where would it end? I mean, you would have to put limits, but by doing that, you could, it would have to be a case-by-case issue, which could get tedious. So it's kind of a big picture issue that the court's going to have to just make an opinion on. I mean, luckily for them, they have this opportunity, but the opinion that comes out may not necessarily be so black and white as our brief suggested that it could be, because you want to just make sure that it's there if they need it, but it's not having to be applied every time. So that kind of summarizes everything in as tight as possible. Any questions? Yeah.